Yes, Krishnappa. Oh.
Evidence conviction of accused number 2 for 392.
Yeah, these are 4. ಏನು ಇವಾಗ ಹೆಂಗು 9 ವರ್ಷ ಇದಾರಲ್ಲ ಒಳಗಡೆ ಏನು ಆಟೋಮೆಟಿಕ್ ಎಸ್ ಸರ್ ಕ್ಲೋಸ್ ಬರ್ತಾರ ಕಾಲ ಬರ್ತಾಮ ಆರಾಮಾಗಿ ಕೂತ್ಕೊಂಡು ಮತ್ತೆ ನಮ್ಮನ್ನು ಬೈಕೋಬಾರ್ದು ರಾತ್ರಿಗೆ ಒಂದು ಇದಾಕಿ ತಪ್ಪಲ್ಲ ಮೆಟ್ಲು ಬೇಕಾ ಕಂಫರ್ಟ್ ಕೂತ್ಕೊಳ್ಳಿ ಅಮ್ಮ ಚೇರ್ ಸ್ವಲ್ಪ ಹೇಳಿದ ಚೇರ್ ತೆಗೆದು ಬಿಡಿ ತೆಗೆದು ಕಟ್ ಆಗ್ಬ ಹಿಂದೆ ಬೆಂಡ್ ಹಾಕಿ criminal the impugned judgment of conviction, order of sentence dated 22nd 2017, made in session case file of the 5th Additional District and Session Judge Mangalore at Puttur, convicting the accused 1 and 2 449 392 section 34 IPC. Next part. The case of the prosecution that the accused number 1 is the resident of Karkalli, KRKLLI, Karkalli Bene, house of Nagarur village, Karnataka district, and married the daughter of Monu, resident of Pondankeri of Kodiambala village, Puttur Taluk, the resident of Haryala house of Blue village, Beltangiri Taluk, and married the daughter of Mamuhini MAMMNIHI, resident of Pandageri, Kodimbala village, situated nearby the house of the wife of the one. Came to know each other while coming class and become close to each other. Number 2, earlier supplied a laterite stone sand to one baby alias Thomas house in survey number 1.1, but Delia, the village, and maintain good relationship. The accused number 2 The accused number 2 shared this fact with the accused number 1. That baby alias Thomas and his wife Mary, only two were residing in their house. At the time, the accused number 2 shared his financial difficulties. Hence, both in furtherance of common intention for gaining money, wrongfully decided to rob the gold ornaments by baby alias Thomas and his wife. Case of the prosecution. On 25/9/2012, they brought the motorcycle of the accused number 1 from his house at Somwarpete, bearing registration number KA 09L3165. While coming, purchased 2 knives from the market. Whether you have examined the shop owner of the knives, the market of Somwarpet reached Kodimbala at night 12 p.m. They by switch off their motorcycle, pulled the motorcycle near the house of Thomas, park it. There on the guise of that motorcycle was out of order. And Thomas, in order to drop them in their in-laws' house, them in his car, bearing registration number KL10P5009. Number 2 was sitting in front seat and accused number 1 sitting in the back seat of the car. Person furtherance common intention asked him to stop the car at Bolur Cross. Stopped the car. Accused number 1 stabbed the neck of the Thomas, right side by knife. When he tried to escape, the accused number 1 held him both and back. That time, accused number 2 stabbed the neck. Thomas was causing bleeding injury. Thereby, they committed the murder of Thomas. Gold filling chain weighing 34.600 grams and worth rupees 9,800 from his neck. ರಾತ್ರಿ 12 ಗಂಟೆಗೆ ಯಾಕೆ ಅವರು ಕತ್ತಲ್ ಹಾಕಿ ಮಲಗ್ತಾರೆ? ಇವ್ರು 12 ಗಂಟೆಗೆ ಹೋಗ್ತಾರ್ರಿ ಅವ್ರ ಮನೆಗೆ. ಅದು ಎಬ್ಬಿಸಿದ್ರು ಗಿಬ್ಬಿಸಿ ಏನೂ ಇಲ್ಲ. ಹೋದ್ರು ಅವ್ರು ಡ್ರಾಪ್ ಮಾಡಿದ್ರು. ಹೋಗಿ ಅವ್ರು ಎಬ್ಬಿಸಿದ್ರು ಏನೂ ಇಲ್ಲ. 12 ಗಂಟೆಗೆ ಹೋದ್ರು ಬಂದ ಡ್ರಾಪ್ ಮಾಡ್ದ. 12 ಗಂಟೆಗೆ ಸಾಲ ಬೈಕ್ ಕಟ್ಟಿ ಹೋಗಿ ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. 12 ಗಂಟೆಗೆ ಹೋದ್ರೆ ಯಾರು ಚೈನು ಕತ್ತಲ್ಲಿ ಎಲ್ಲ ಹಾಕೊಂಡು ಮಲಗಲ್ಲ. ನೈಟ್ ಎಲ್ಲ ತೆಗೆದು ಸಾಕಿ ಮಲಗೋದು. ಎಲ್ಲ ಕ್ರಿಯೇಟೆಡ್ ಸ್ಟೋರಿ. Thereafter, they took the car. ಇದು ಅಲ್ಲಿ ಅವ್ನು ಕಿತ್ಕೊಂಡು 9,800 ರೂಪಾಯಿ ಕಿತ್ಕೊಂಡು ಅವ್ನು ಬಿಸಾಕ ಅಲ್ಲ ಹೋಗ್ಬಿಡ್ತಾರೆ. ಮತ್ತೆ ಎಷ್ಟು ಧೈರ್ಯದ ಬರ್ತಾರ್ರಿ ಅವರು ಈ ಕಡೆಗೆ. ತೀರಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ ಸಾಕು, ಹೋಗಬಿಡೋರು. ಮತ್ತೆ ಯಾಕೆ ಬರ್ತಾರೆ ಇಲ್ಲಿ? Thereafter, they took the car, the house of the said Thomas, along the dead body, parked the car a little distance, the house road, trespass into the house of Thomas by pushing the door forcibly. ಅವ್ರು ಬಾಗ್ಲ ಹಾಕಿರಲ್ವಾ ಅಮ್ಮ ಆಚೆ ಹೋಗ್ಬೇಕಾದ್ರೆ ಅದು ಹೆಂಗಿಲ್ಲಿ ಬಾಗ್ಲ ಬರ್ತಾರಿ
ಅವ್ರಿಗೆ ಗೊತ್ತಿರ್ತಾರಲ್ಲ,
ಅವ್ರಿಗೆ ಗೊತ್ತಿರ್ತದಲ್ಲ ಯಜಮಾನಕ್ಕೆ ಹೋಗ್ದ ಅಮ್ಮ ನೋಡೇ ಕೂತ ಇರ್ತಾಳೆ ಎದ್ದೇ ಇರ್ತಾಳಲ್ಲ.
ಕರ್ಕೊಂಡು ಹೋದ ನಮ್ಮ ಯಜಮಾನ್ರು ಅಂತ
Forcibly with the intention to kill and rob the god ornaments. Accused number 1 held the wife of the Thomas, Timothy Mary, and accused number 2 closed her mouth, stabbed the knife on her neck, murdered, and removed her studs weighing 4.100 grams, cash of 8,400. ಅಲ್ಲಿಗೆ ಹಾಕಿ ಬರ್ತಾರ್ರಿ, ಬರೀ 8,400 ರೂಪಾಯಿಗೆ ಯಾಕೆ ವಾಪಸ್ ಬರ್ತಾರೆ. And coupled on 2 mobile sets, Lava company, American company, thereby committed offense under the 449, 392, 302 for IPC. Sir, the complaint, Krishnappa, according. ಇದು ಕೊಡಿ ಅವ್ರದ್ದು. One Kunnappan was working in rubber plantation with deceased persons since 1.5 years. Third incident, after working till noon at about 25/9/2012, and after tracking deceased person, went to his house. ಎಷ್ಟೊತ್ತು ಹೋದ ಏನೂ ಇಲ್ಲ. When he returned to the garden, the deceased persons on 26/9/2012 AM for rubber tapping was worker till 6:45 PM. At that time, found baby Thomas. ಅವನು ಬೆಳಗ್ಗೆ 6:15 ಬಂದ ತಕ್ಷಣ ಗೊತ್ತಾಗ್ಬೇಕು ಅವನಿಗೆ ಏನಾಗಿದೆ ಮನೆಯಲ್ಲಿ ಅಂತ. ಅಮ್ಮ ಅಂತ ಬಾಗಿಲು ಹೊಡಿತಾನೆ, ಬೆಳಗ್ಗೆ ಬಂದ ತಕ್ಷಣ ಬನ್ನಿ ಕೆಲಸ ಬಂದಿದ್ದ ಮಾಡ್ತಾನೆ ಮಾಮೂಲಿ, ಮಾತಾಡ್ಕೊಂಡು ಹೋಗೋನು. ಬೆಳಗ್ಗೆ ಬಂದು ಬಾಗಿಲು ಹೊಡಿತಾನೆ. ಎಲ್ಲ ಸ್ಟೋರಿಲಿ ನನಗೆ ಡೌಟ್ ಅವನೇ ಸಾಯಿಸ್ಬಿಟ್ಟಾನ ಅಂತ. PW1 He did not found baby Thomas, wife Mary. As usual, deceased persons were struck with cattle who are doing garden work. But on 26/2012 till 45 AM, did not see them. Therefore, we went to the house. ಎಲ್ಲ ಹೋಗ್ತಾನೆ CW2 ಮನೆಗೆ, ಇಲ್ಲೇ ಕೇಳ್ಬೇಕಾಗ್ತವನು, ಇಲ್ಲ ಬಾಗ್ಲೋಡ್ದಾಗಿತ್ತಲ್ಲ. Went to the house of PW2, ಯಾರು PW2 PW2 to inquire as to whether they want to go to the village. They have asked cattle, and thus they inquired with PW2, who showed ignorance, saying they did not tell anything. They did not tell anything to him. PW2 also stated that on the night 25/9/2012, baby Thomas and his wife Mary were present. Thereafter, PW2, the wife of PW2 and 3, wife of PW2 came together to the house of the deceased and saw that one front door was kept open, another was closed. When PW1 to 3 went inside the house, in all, Mary Thomas fell down, facing towards ground in a pool of blood. He was dead. Shocked. By then, they standing in the house. They saw the opposite. Found the distance of 50 meters from the house in a rough road, a car of baby Thomas was stopped. 3 persons went near the car, saw the baby Thomas was sitting like a position in a driver's seat, leaning towards left side and dead. ಎಲ್ಲ ಸ್ಟೋರಿ ಇದೆ. ಅವನು ಬೆಳಗ್ಗೆ 6 ಗಂಟೆಗೆ ಬಂದ ಕಾರಲ್ಲಿ ಬಿದ್ದು ನೋಡಲ್ವ, ಅವನು ಪಕ್ಕದ ಮನೆ ಅವನು ಬಂದ ತಕ್ಷಣ ಅದೇ ನೋಡ್ತಾನೆ. ಎಲ್ಲ ಕ್ರಿಯೇಷನ್. He sustained injuries to the neck and blood was poured. ಅವ್ರ ರಾತ್ರಿನ ಹೊಡೆದಾಕ ಅವ್ನು ಎಲ್ಲಿರ್ತಾರೆ ಎಲ್ಲ ಮುಗ್ದೋಗಿರ್ತದೆ, ರಾತ್ರಿ ಬ್ಲಡ್ ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ. Car was closed. Then CW2 intimated the matter to the police through phone. Again PW1 to 3. Again PW1 to 3 came near the house, saw the through open window and found one other. ನೋಡಿ ಸ್ಟೋರಿ ಹೆಂಗಿದೆ. ಅಮ್ಮ ಸತ್ಲು, ಆಚೆ ಬಂದ್ರು, ಮತ್ತೆ ಅವ್ರು ನೋಡಿದ್ರು, ಮತ್ತೆ ಒಳಗಡೆ ಬಂದ್ರು, ಮತ್ತೆ ಬೀರು ನೋಡಿದ್ರು. ಅಲ್ಲೇ ನೋಡ್ರು, ಸತ್ತ ತಕ್ಷಣ ನೋಡ್ಬೋದು, ಬೀರು ಕಾಣಲ್ವಾ? ಸುಮ್ಮನೆ. Found that one Almara kept bedroom and open. Class papers, other articles of Almara was scattered on the ground. First ಹೋದಾಗ ಗೊತ್ತಾಗುತ್ತೆ ಎಲ್ಲವೆಲ್ಲ. Some culprits with the intention to rob gold from the house of the deceased person. On 25/9/2012 during night, cut Mary in the hall of the house and cut the neck of Thomas in the car. The sharpest weapons. On the base of the complaint lodged, the judicial police registered the ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್, ಅದು ಎಲ್ಲಿದೆ, ಇದೆಲ್ಲಿದೆ ರೀ ಕಂಪ್ಲೇಂಟ್, ಎಲ್ಲಿದೆ ಅಪ್ಪ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆಪ್ಪ? On the basis complaint by PW1, the judicial police registered the crime number 98/2012 under the provisions of section 302 IPC on 26/9/2012 12:30 PM. After investigation, police filed charge sheet against the accused 1 and 2. So the session judge, learned session judge, claims of the accused persons, framed the charge against the accused 1 and 2 and read out to him after investigation. Which file charge sheet against the accused. Section 449, 302 and 302. Framed the charge, door, the accused persons, along with not them, who denied, pleaded not guilty and tried to be tried. Order to prove the case of the prosecution. The prosecution now examined PW1 to PW 42. Detailed documents exhibit P1, P74. The exhibit D1 portion marked the portion of state 5 was marked as exhibit D1. Objects MO1 to 18. Objects marked MO1 to 18. After come of the evidence of prosecution witnesses, statement of the accused persons, provisions of section 3(1) CRPC. Correct. Denied incriminating circumstances appearing the evidence of prosecution witnesses against them, but they did not choose to lead any defense evidence. Stop. But the accused persons filed separate statement under the provisions of section 313 plus 5 of the CRPC. One has produced Xerox copy RC motorcycle bearing number KA09 L3165 17, and also another bearing number CL 2884 of Nitya Nidhi Devanti Sangarsha dated 30th 4 2012. Balaji Finances. Market having paid pygmy amount of rupees 90,000 by the accused paid the statement. Stated by the accused number 1. The entire allegations against the accused prosecution are all false and not prosecution are not, they are not involved. The alleged incident occurred on 29/10/2012. The inquiry officer has not recovered either gold chain, gold mobile, not belongs to the deceased persons. All the material objects created by the inquiry officer at the instance of the members of deceased persons only to implicate accused number 1. Other allegations. Number 2, also filed statement under section 313 denied the allegations made and inquiry officer created all the falsely implicated. The accused number 2, nothing to do with offense or nothing to do with material objects recovered and not recovered from him. Based on the opposite deeds, the learned session judge framed 4 points for consideration. Considering all the points affirmative that the prosecution has proved beyond reasonable doubt that 25/26/9/2012, the intervening night, the homicide death of Thomas, wife Mary Thomas, Kollur Cross, Dilia, Kamboli village, Puttur Talak. And there was a motive for the accused person to commit the murder of the deceased person. Further recorded a finding that accused number 1 and 2 is common intention to rob the gold ornaments of the deceased person came to the house of baby Thomas in a motorcycle KA09 L3185 at about 12 o'clock night, 5/9/2012. And Thomas baby Thomas now dropped them to their in-laws' house, took them in his car bearing number KL10 T5009. Accused number 1 was sitting backside, and they asked the car to stop at Bellur Cross. And they stopped the car. The accused number 1 stabbed. Accused number 1 and 2 stabbed the Thomas forcibly, caused stabbed on the neck by knife, MO 1 and 2, and caused forcible bleeding injury. Thereby, they committed the murder of David Thomas and robbed 34,600 grams worth about 90,800 from his neck. Thereafter, they went to the house of his house and stabbed the wife of the Thomas, Mary, and removed her gold earstuds, weight 4.100 and cash rupees 8,500. Thereby, they have committed the offence punishable with the provisions of section 449, 302, reduction 34 IPC. Section further recorded a finding that in furtherance of common intention, Mary Thomas robbed the golden ornaments of the kept in cupboard sets. Thereby, they committed an offence from the provisions of 1592, with section. Accordingly, the Lallad Session Judge proceeded to convict the accused persons for the offence from the provisions of section 449. Rigorous imprisonment of 10 years, fine of rupees, and life, fine of rupees 3,000. For a period of 10 years, fine of rupees 5. It is fine. Watch list. In these appeals, Criminal Appeal 118/2017, filed by whom? A1. Criminal Appeal 1318, filed by AP. Hence, the present two appeals are filed. counsel for the partition. Mustapha, learner counsel for the accused person. Appellants contended that the court the accused person made out to charge them is erroneous, contrary to material record, and cannot say. Stop. Contended. Or utter strangers, the witnesses. No TIP was conducted. PW3 identified since one time before the police station, the court. Options of TIP, test identity blood, the learned judge is not justified in convicting the for the offense of the offense of 449, 302, and 392 IPC. Contended. The investigation case was registered on 26/9/2012, and the investigation started, and the accused was arrested only on 29/10/2012, more than one month by the IO. The PW6, the witness to the recovery of mobile was not support the case of the prosecution. PW13, 14 also not support case of the prosecution. So we further contended PW11, 12, and 15 support the case of the prosecution. And capital MO 1 to MO 1 to 11 stains with the blood. MO 9 and 10 the O group blood. MO 11 A group blood. Exhibit P52, 55 Shiraz report not proved. So we would further contended the original charge sheet filed on 17/8/2006 after lapse of 4 years, which is permissible. Delay in the constitution of the accused and arrested after 1 month, that is on 29/10/2012, not explain the prosecution. Thereby, it is a fatal, the case of the prosecution. So, we would further contended that the fingerprints of the accused and the car MO 15 is not proved. Exhibit P9, bank statement of accused number 1, depict the transaction from 1/1/2012 to 31/12/2012. So, we would further contended that there are no eyewitnesses. The spot, the entire case of prosecution mainly on the basis of circumstantial evidence. And exhibit PW8 is one of the circumstantial witness last seen the accused not proved. That W owner of the shop was not examined. Thereby, the learned session judge proceeded to convict the accused only on the basis of the presumption observances supervision. Therefore, he sought to allow the appeal. Stop. He further contended there is no. Therefore, sought to allow the appeal. Prayer. The further contended that there is no link from the beginning till the end. Thereby, the prosecution failed to prove beyond reasonable doubt the involvement of the accused in the homicide death of the deceased persons. Thereby, the input order passed by the telecast not be sustained. In support of contention, the counsel was relied upon the term of the Honorable Supreme Court. (2011), yeah, 2011. Yeah, 2011. In case of Varun Chaudhary versus State of Rajasthan, yeah, 2011, SC 72, paragraph 23 in bracket, to loss in theory. 15. Case of Marap alias Marap Reddy, alias State of Karnataka, 2015, in bracket 4, KCCR 2946, 2946, paragraph 2016, in the case of state of the state of Karnataka by Nyamati police station, Nyamati versus Kandraj, reported in 2011-5, paragraph 21-22, 2005, Karnataka, ILR 2005 Karnataka 2576, paragraph 13, regard concrete evidence. For contra, Sri Nageshwar for learned counsel for the learned the informed judgment of permission order passed by the judge intended payments that there are six circumstances to prove the involvement of the accused of the deceased persons. Namely, PW 1 to 3 deposed that there too was for supplying building materials to the deceased at the time of constructing his house. Contended. The last scene theory, last scene, accused 1 and 2, along the deceased by PW8, who identified the accused 1 and 2 before the police station. Also, bike MO17, the accused. He would further taking of the accused custody, right, by PW and exhibit P27, recovery of MO 16 cash of rupees 1,500. 14, mobile set under the thousands of 7 by PW9 from the accused clearly depicts the involvement of the accused. Home side death of deceased. We further contended. MO 5 knives 1 and 2 recovered under exhibit MO 4 and 5 other issues were recovered. Under exhibit recovery ಆಗಿದೆ ಯಾವುದು? 4 and 5 ರೀ. MO 4 and 5 recovered which matter?
With P27. PW13 with this. And MO4 and 5. Next.
MO 4 and 5 knives recovered under the exhibit P
27.
27 matches with the MO 7 and 8 pant and shirt of the accused. So we would further contend it. The fingerprint of the accused persons on the glass of the car found MO 15. Stop. The exhibit P38, 58 to 59, 60. The FS officer clearly proves the involvement of the accused. Wrong said that. Thereby he sought to discuss the appeals. It was not so. Okay. ಆಯ್ತಾ ಇಬ್ರು ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು? ಏನ್ರಿ ಲಾಯರ್ ನಮ್ಗೆ ಸಹ ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ, ತೊಂದರೆ ಕೊಡ್ತೀವಿ. One. Kunnappan, the complainant for working on the disease, large complaint against the unknown persons. PW, no person support the case of prosecution. Of the complaint should be won by the PW1 clearly depicts that when he went to the garden of the deceased persons 9 to 12 about 6:30 a.m. as usual, he found Thomas or his wife Mary not found. Usual, they came to the house, out of the house of 6:45 a.m. they used to start milk from the cattle. Thereby, he inquired that they have informed anything. PW2 said they were not said. Both went along with PW3, went and see the house of the deceased. The front door was closed, the other door was open. They went inside. The baby Thomas, baby alias Thomas, Mary, a baby alias Thomas, baby alias Thomas, the wife of the baby Thomas alias Mary, baby alias Thomas, wife Mary, died. Died. House. One patient was thrown full of blood and died, shocked by them. They found about 50 meters away the house in a rough road. Car of baby Thomas stopped. They went near the car, saw the baby Thomas who was sitting like a position in a driver's seat, leaning towards left side and died. And also observed that had injuries on the neck, blood was pooled. Again, they came back to the house and found all the almirah, found that one almirah kept in bedroom open, cloths, papers, other articles were scattered on the ground. Culprits have been killed. The intention was rob gold ornaments from the house of dead persons. Thereby lost the complaint. Lost the complaint by PW1 on 26/9/2012 at about 12 p.m. According to the jurisdiction of police registered case in claim number 98/2012 for the offences made out in the charge memo. Next paragraph. A careful the evidence of PW 1 to 3 deposed that A2 was supplying building materials to the deceased at the time of construction their house. They are not the eyewitnesses. The deceased. According to PW1, as usually came of deceased persons in the garden. When he was not found, the deceased persons even after 6:45 p.m. Then he went to PW2 and PW3 came to the spot. Stop. None of the witnesses deposed about the involvement of the accused persons, the homicide of the deceased. Though PW1, 1 to 3 stated death and admittedly complaint lodged against the unknown persons. Stop. PW8 who identified accused number 1 and 2 and by MO 17 used by the accused. not mention the number motorcycle, nor he asked the or spoken to the he further stated that after he came to know about the death of the deceased persons, he stated that the Mary Thomas body was found in the house, and there were and she was full of blood. All the materials in the house scattered. Somebody in order to rob the ಸ್ವತ್ತುಗಳು ಅಂದ್ರೆ materials, they killed the deceased and robbed as he came to know. He further deposed that on 25/9/2012, when he was going on personal work, Mangaluru, came back late night in his motorcycle. There, you see the young boys, the Yamaha motorcycle. They seen some light of from the light of headlight, the of his light of headlight of his motorbike, and did not spoke to them, and he had not identified the number of after 1 month, that is on 29/10/2012, the police summoned him and shown the accused persons 112 police station. Thereby he identified the accused persons. Further stated that he know both the accused persons. And identified both are before the court. In the cross examination, is admitted that on 26/9/2012, they gave a statement in the house of the baby Thomas, year 2012, and has given numbers, mobile numbers used by him, and is admitted that he has not identified the two persons no statement was made to the before the police. He denied that the person he has seen is strangers. He voluntarily stated that the person he has seen known to him where they are residing. And the person known to him and where they are residing now stated before the police on 26/9/2012 in his statement. He further admitted in examination that the police have not shown any materials in the house except showing the accused persons. After showing, based on the police statement, we came to know these persons killed the deceased for the robbing of gold ornaments and mobiles. So, the examination of PW1, both the examiner chief and examination, not inspired the confidence of this court that he identified the persons killed, deceased of another corroborative evidence, the evidence of PW8, who could not able to identify the persons and bike doubtful. It is also not in dispute that when there are no eyewitnesses, and when PW8, the last scene, the witness of last scene, Didi, not able to identify the accused persons, or could not identify the number of the vehicle used on the previous day. And first time on the statement made by the police, he identified the accused person only in the police station first time, as well as court. Thereby, investigation officer conducted TIP in the present case. No TIP was conducted except the oral statement of PW1 to 3 that involvement of accused 1 to 3 homicide death of deceased. PW1 to 3, they are not eyewitnesses. Only on the statement made by the police, they have identified the accused persons first time in the police station. So, it's also relevant to know, according to prosecution, the accused persons purchased the knives from the shop, whose the offense as exhibit exhibit knife free. MO 4 and 5. Admittedly, the owner of shop where the purchase is not examined. So, the taking after arresting the accused, persons after 1 month, is on 29/10/2012, on their voluntary statement made, the accused person, the investigation officer, recovered bike, MO 17 by PW 29, the exhibit P27 of MO 16, cash of 27,500, and MO 14, mobile set lava, bracket release. The exhibit P37, Mr. Maja dated 30/10/2012 by PW 29 from the accused. Code MO 4 and 5, the accused, and the exhibit P27. Matches with MO 7 and 8, pant and shirt of the accused. The learned session judge proceeded to convict the accused mainly on the basis of the recovery of material objects and only on the basis that the murder for gain, lossy thief, except recovery of the knife, bike, and the material objects, ornaments. Gold chain release, gold release recovered on the basis of the evidence of PW 11 and 12. Stop. Exhibit mark receipt mark agidala. Though the receipt was signed by the accused number 1, issued by PW 11, not marked, the learned session judge proceeded to convict the accused based on the aforesaid recovery and statement made by jewelry owner. The fact remains that on careful perusal of the entire material record, the prosecution failed to prove beyond reasonable doubt the involvement of the accused persons in the potential death of deceased, except that in the present case, last theory not proved. Learned session judge proceeded to convict the accused only on the basis of recovery. Absolutely, there is no material produced before the court about the involvement of the accused 1 and 2 regard to homicide death of the deceased person. All details ಮಾಡಿದ್ರೆ phone number though. The investigation officer has not collected the call details of the accused 1 and 2, nor a mobiles are seized. Recovery of M1. Support 12 of 30 and recovery of cash, recovery of the gold jewelry M1 and cash of rupees 27,500 are the instance of the accused persons based on their voluntary statement as well as statement of PW 11 and 12 cannot be a ground to convict the accused persons. Absolutely no material produced by the prosecution. So, robbery and murder form part of the same transaction. The presumption that the accused committed murder cannot be drawn merely based on the recovery. The entire prosecution case against accused person is only based on the recovery of MO 1, MO 12, that's 12, 13, gold studs and cash. Absolutely, there is no material to prove this person committed the murder of the deceased so to attract the provisions of section 302 IPC. It is well settled that careful perusal of section 27 of the Indian Evidence Act makes it clear. Said the section based upon the fact actually discovered in consequence of information given, some guarantee is afforded, thereby that the information was true, accordingly can be safely allowed, given in evidence. But where the facts are such as indicating reasonable doubt as regards to the guilt of the accused, benefit of same should be availed to the accused persons. The material on record clearly depicts that though there are ingredients charged framed by the session court with regard to robbery for personal gain, and this is to attract the provisions of section 392, 302 IPC. Where the recovery of gold studs and chain and cash from the accused and production same by the accused during the course of the investigation can lead the presumption that the accused persons have committed the robbery or received the stolen property. But there are no circumstances proved beyond reasonable doubt by the prosecution that the robbery and murder took place on the same transaction in the absence of any eyewitnesses or any circumstances connecting the accused as held by the learned session judge, 6 circumstances, the accused could not liable for the offence on section 302 IPC, as the prosecution has not proved the chain circumstance leading involvement of the accused in homicide of the deceased. Push up. The learned session judge recorded a finding at clause 70 of the judgment. The circumstances of 6th being none of the circumstances proved the involvement of accused persons homicide of the deceased, except proving the recovery of MO 12 and 13 thirds of the deceased Mary and the evidence of PW 11 and 12 who identified the accused number 1 and issued receipt for pledging. None of the circumstances prove the involvement of the accused homicide of the deceased. In the absence of any material record based on the suspicious circumstances and apprehended the accused 1 and 2, and based on the voluntary statement, the investigation officer recovered the MO 13 sets and cash. Presumption can be drawn. Robbery was committed for gain. Thereby, the accused are liable to punish the provisions of section 392 IPC. In the absence of any other corroborative evidence to involvement of the accused homicide of the deceased, is not possible, can convict the accused provisions of section 2 IPC, Redwish section 34. Put up. On careful perusal of the entire material record and the evidence of the prosecution witnesses about the involvement of the accused persons with regard to homicide, absolutely there is no material produced by the prosecution to prove the involvement of accused persons in the homicide of deceased, except recovery of jewels and cash based on the voluntary statement of the accused and the statement of PW 11 and 12. Stop. It is also not in dispute that the PM report PM report the PM report issued by the doctor who examined Mary, you put the Rebecca. exhibit clearly cause of was due to shock and hemorrhage as a result of injury sustained to neck. The FSL report with the B, exhibit B, FSL report yesterday. Exhibit
53.
53 and the evidence of people 36 clearly depicts blood stains exhibits serial numbers for subject serological analysis. Cuttings scraps were completely utilized for serology work. Serology report will be sent in due course. Accordingly, exhibit P55 serology report clearly depicts that blood group of stains in items A2, B2 could not be determined because of the results of the test were inconclusive. Stuff. None of the material documents relied upon by the prosecution beyond reasonable doubt that the involvement of the accused homicides the death of deceased. On reapplication of the entire oral document evidence on record, and in the light of the dictum of the Honorable Supreme Court and this court, time and again held based on the circumstances as held Viral Chand Sarda of the state of Maharashtra 1984 4 SCC, wherein the Honorable Supreme Court at para 153 wherein the Honorable para 154 where of the considered opinion, the recovery of gold studs, gold chain and cash from the accused persons based on the voluntary statement and the statement of PW 11 and 12, but failed to prove the involvement of the accused persons in the homicide death of deceased beyond reasonable doubt. As per illustration in bracket A of Section 114, Evidence Act 1872, though recovery of articles can lead to presumption that the accused have committed robbery, stolen property, or received the stolen property, unless there are other circumstances to show the theft, robbery, and the murder took place in the same transaction, liable for the offences punishable on the basis of Section 302, Section 34 IPC. Thereby, the circumstance narrated by the learned judge holding circumstances in the circumstances, the learned session judge here holding used the offences punishable 302 IPC. Considering the totality of the factors of the present case and on the basis of presumption, permissible under registration A of section 114, the Evidence Act, the accused 1 and 2 are liable to be convicted for the offence punishable with the provisions of section 92 IPC. Our view is fortified by the dictum of the Honorable Supreme Court in the case of Rajkumar alias Raju versus State of NCT Delhi, reported in AR 2017, SC 614, paragraph 10, 11, 13, paragraph 10, 11, 13 held as under. Sri Krishnappa, learned constitution for the accused, relied upon 11. In terms of the Supreme Court, the Honorable Supreme Court, while considering contrary evidence in the case of Varunana Chaudhary versus State of Rajasthan, AER 2011, SC, page 72, paragraph 23, held as under. Admittedly, in the present case, none of the prosecution witnesses identified the persons on the motorcycle, nor identified the number of the motorcycle, including PW8. Thereby, the said judgment is squarely applicable to the present case. The another judgment, 2015 Kodi. The Honorable Supreme Court, while considering provisions of Code of Bench of this court, considering the provisions of section 302 IPC, held that for fingerprints, the accused bottle of the alcohol not sufficient when last seen circumstances. Recovery of ornaments not established beyond reasonable doubt. Admitted in the present case, the fingerprints alleged not proved by the FSL report exhibit as the serology report is inconclusive. Except based on the recovery requirements, it is not possible to held. It is not possible to held recovery, nor shape aside to hold the guilt by the prosecution failed to prove beyond reasonable doubt the involved accusing himself with the disease. The Honorable Supreme Court, the thousands of in the case of Karnataka by Nyamita police, Nyamati police, was Chandraj reported in 2016, 2 cases CR 1175. Paragraph one and held as an Siddhartha sleeper reported in 2005, Karnataka 76 held. Unless some concrete evidence used, unless there is some concrete evidence, point out the possibility of accused being culprits, does not unerringly point out their guilt with certainty, accused are entitled to the benefit of doubt. Paragraph 13 as held as under. Next paragraph. On reappreciation of the entire material record, the accused, the prosecution is able to prove only the provisions of section 392, recovery of gold studs and cash. As we have not stated anything in the 313 statement, except class 5 of the CRPC that stated at the instance of investigation officer. We have the control opinion, the prosecution proved out all of the accused committed the robbery and robbery or recovery stolen property at the instance of accused attract the provision of section 392 APC, and thereby the prosecution failed to prove beyond reasonable doubt the involvement of the accused persons, province of the absence of conviction or the input judgment conviction passed by trial court convict the accused number accused province of the IPC cannot be sustained. The stated above point raised case present appeals is also party in affirmative hold made out a case to interfere with the input judgment and order of conviction only insofar the accused 1 and 2. The offense was the thousands of section 302. Fine. 4 ಇಲ್ವಲ್ಲ Also, near the opposite material facts stated material on record. The opposite, the opposite plate indicates when failed to prove beyond reasonable doubt the involved accused persons once and the received to attack the provisions of section 302 of invoking provisions on section 449 IPC against the accused would not arise. The position stated about so and so. With the improved judgment of order of conviction, convicting the accused 1 and 2 for the offence punishable in provisions of section 49 302 IPC. In excess of our applied powers of this court, under the provisions of section 374 of clause 2 of the Code of Criminal Procedure, and the improved judgment are passed by trial court in so far convicting the accused 1 and 2 under the provisions of section 449 302 edition 34 IPC is are liable to be set aside, and the punishment imposed by the trial court provisions of section 392 proper. Yes. Yes. We pass the following. The criminal appeals are allowed in part. Judgment part of sentence by the court. The offence which provisions of the 302 449 IPC, that is 34 IPC. Sentencing them undergo undergo yes, life, the fine of rupees 5,000 and 3,000 respectively. Are hereby set aside. 1 and 2. The offence was provisions of section 449 not 2 edition 34 IPC. The impugn judgment of conviction order passed trial convicting the accused under the provisions of section 3 IPC for a period of 10 years with fine of rupees 5,000 is hereby confirmed. The accused are entitled for 10 years. 10 years. Accused are entitled set up under the provisions of section 428 Code of Criminal Procedure. Ten years, 5,000 default. Will announce 5,000 ಇದೆ. ಅವರು ಕೊಳ್ಳಿ ಆಮೇಲೆ ಹೋಗ್ಲಿ ಬಿಡ ಮಕ್ಕಳು ಇನ್ನೊಂದು 2 ವರ್ಷ ಇರ್ಲಿ ಅಷ್ಟೇ. ಏನಿಲ್ಲ ಸರ್, ಇನ್ನೊಂದು 2 ವರ್ಷ ಇರ್ಲಿ ಬಿಡಿ ಸರ್.
This advocate was not appearing. Therefore, the telecast is disposed of.
Each of the after liberty 5,000 each of class 2 years. Class 2 years. 392 10 years. Fine of rupees 5,000 each. In default 2 years. Itself, the main appeals are disposed of on rates. IA 3 of 18, 2018 for suspension would not serve in IA 3 also disposed of. ಅವ್ರು ಮಾಡ್ಕೋತಾರೆ ಬಿಡಿ.
ಇಲ್ರಿ ಬಿಟ್ಟಿರ್ಬಲ್ಲ ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ 10 years
10 ವರ್ಷ. All right. The registry directed to communicate the operative portion of the judgment to the jail, so and so forth with. ಏನೋ ಸೆಟಪ್ ಗಿಟಪ್ ಇರ್ತದೆ, ಬಿಟ್ಟು ಹೋಗ್ಲಿ ಅಂತ ಅಲ್ಲೆಲ್ಲ ಲೆಕ್ಕ ಹಾಕ್ತಾರೆ. 6 ತಿಂಗಳು ಬೇಗ ಬಂದ್ಬಿಡ್ತಾರೆ. ಆಯ್ತು.
10 years 1 year. 10 years 1 year ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಕೆಲಸ ಮಾಡ್ತಾರೆ.
ಮಾಡಲಿ ಬಿಡಿ.
12 ವರ್ಷ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
10 years ಗೆ 1 year.
ಕನ್ಸೆಷನ್
10 years ಒಳಗಡೆ ಇದ್ರೆ
ಎಲ್ಲರಿಗೂ
ಅಲ್ಲ 10 years ಒಳಗಡೆ ಇದ್ರೆ
10 years.
ಸರಿ ಚಂದ್ರಾಸ ನಾವ್ ಯಾಕೆ ಹಾಕಾಗಲ್ಲ. 12 ವರ್ಷ ಇದು. ಕೊಡಿ 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 ಕೊಡಿ. ಈ 12 ವರ್ಷ ಟೈಮ್ ಕೇಳಂಗೆ ಇಲ್ಲ ನೀವು. ಕೃಷ್ಣಪ್ಪ, persuading us 3 days, you have done justice to your party. ನೀವು ನಮ್ಮಲ್ಲಿ ಕ್ವಶನ್ ಕೇಳಬಾರ್ದು, ನಮ್ಗೆ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ. C02 ಇವ್ರು ಯಾರು? ನಂಬರ್ ವೈಫ್ ಅಂಡ್ ಹಸ್ಬೆಂಡ್. ವೈಫ್. ಓ ಇನ್ನೇನು ಹಂಗಂದ್ರೆ ಮುಗಿತಲ್ಲ ಸರ್. 2 ಡೈನ್ ಡಿಕ್ಲರೇಷನ್ ಯಾವ್ದು ತಗೋಬೇಕು? ಅಲ್ಲ ರೀ, 2 ಡೈನ್ ಡಿಕ್ಲರೇಷನ್ ವಿಚ್ ಪ್ರಿವೈಲ್ ಹೇಳ್ರಿ. ಮಾಡಬಾರ್ದು ಅಂತ ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ ಕಾನೂನು ತೋರಿಸಿ. ಗೊತ್ತಿಲ್ಲಪ್ಪ. ಯು ವಾಂಟ್ ಲರ್ನ್ ಫ್ರಮ್ ಯು. ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು, ಡಾಕ್ಟರ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು, ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮಾಡ್ಬೇಕು. ಎಲ್ಲಿದೆ? ಯು ಕ್ಯಾನ್ ಆಲ್ಸೋ ರೆಕಾರ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಫ್ ಆರ್ ದೇರ್ ಅವೈಲಬಲ್ ಆನ್ ದ ಸ್ಪಾಟ್. Only thing that person will make a statement should be sound mind, fit condition ಇರ್ಬೇಕಷ್ಟೇ. sound state of fit mind, sound state of mind ಇರ್ಬೇಕಷ್ಟೇ. ಯಾವುದು ಎಕ್ಸ್ಪೆಕ್ಟ್?
First day declaration is to be P10 malad.
P8.
P10 malad. First day declaration. Second one is to P8 malad.
ಎರಡರಲ್ಲೂ ನಿಮ್ಗೆ ಹೆಸರು ಹೇಳಿದ್ದಾರೆ. ಎಷ್ಟು ವರ್ಷ ಆಗಿ ಮದುವೆ ಆಗಿ? ಓ, C04B ಬಂದಿಲ್ವಾ? C04B ಬಂದಿಲ್ಲ. ಇನ್ಯಾಕೆ?
ಹೋಗಿ ಬಂದಾದ್ಮೇಲೆ ನನ್ನ ಗಂಡ ಇಬ್ಬರ ಜೊತೆ ಇದ್ವು. ಯಾಕೆ ಅಂತ ಕೇಳಿದೆ. ಕೇಳಿದಕ್ಕೆ
ಇನ್ನೊಬ್ಬ ಜೊತೆ ಮಲಗಿದ್ನ?
ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ.
ನೀವು ಸತ್ಯ ರಕ್ಷಂದ್ರು ಅದು ಇಲ್ವಾ? ಮಧ್ಯ 12 ವರ್ಷ. ಟೂ ಡೈನ್ ಡಿಕ್ಲರೇಷನ್ ಇದೆ ಅಂತಲ್ಲ? ಟೂ ಡೈನ್ ಡಿಕ್ಲರೇಷನ್ ಫಸ್ಟ್ ಡೈನ್ ಡಿಕ್ಲರೇಷನ್
apart from that, rodents of mother is also there.
Mother? ಅತ್ತೆ ನಾರ್ಮಲಿ ಸಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು ಮಗಳಿಗೆ. ಇವನು ಒಂದ್ ಸಾಲದ ಇನ್ನೊಬ್ಬಳು ಇಟ್ಕೊಂಡ ಇವನು.
Send the memo to record a second line equation. Here also equal to the effect that the decision wanted to change her statement on after 10 days, after 7 days.
ಕರೆಕ್ಟ್.
Oh. 19 is not.
ಕಾನ್ಸ್ಟೆಂಟ್ ಕರೆಕ್ಟ್. ಈ ಸಾಲದ ನಿಮ್ಮ ಮಕ್ಕಳು ಸಾಯಿಸ್ಬಿಡ್ತೀನಿ ಅಂತ. ಆಯ್ತು. ಎಷ್ಟು ಜನ ಮಕ್ಕಳು? 3 ಜನ ಹೆಣ್ಮಕ್ಳಿಗೆ ಬುದ್ಧಿ ಇಲ್ಲ ಇವನಿಗೆ. ಇನ್ನೊಂದು ಹೆಣ್ಣು ಬೇಕು. ಈ ಹೆಣ್ಣು ಸಾಯಿಸ್ಬೇಕು. ನೋಡ ಅವ್ರು ರಿಪೋರ್ಟ್.
Monday